I think, I may be wrong, I'm wondering about Queens, but I think we have folks from all of the other city district attorney's offices here. I know we have Brooklyn, Bronx, Staten Island, Manhattan. Queens? Hey, Queens is in the back. Nice. Okay, so that's great. So, you know, it's funny, this is kind of a bit of a niche event for us, kind of really focusing in on elected prosecutors. And so our core audience is here, so that's perfect. We're talking today, obviously, about conflicts of interest with taking donations if you are an elected prosecutor. You know, it's an issue that has gotten some attention in the press, but when we went to kind of scrub it and see what guidance was out there, what regulations, you know, there's really nothing. And so we thought it was a good idea to follow up on our report with an event where we could think about other approaches, different approaches than what we at CAPI suggested, and also think about ways to make some of these ideas real changes, mandatory changes, permanent changes, and not just voluntary measures that DAs could do themselves. So what we're going to do is I'm going to introduce the panelists, and then I will spend about 10 minutes summarizing the project that we did and our report and recommendations. And then each of the panelists is going to take about 5 minutes to respond, to talk about what they think about the report and recommendations, other ideas they have, critiques, you know, what they think should happen from here, just a general kind of opening statement, if you will. And then we will proceed with some kind of cross-panel discussion and end with questions from all of you. We had decided on 5 minutes in our prep call because we wanted it to be more discussion than just speeches. So I do have Isaac over here with a 0-minute sign, so he will let each of you know that you have talked for 5 minutes, but you know, don't feel compelled to stop in the middle of your sentence. We have plenty of time, so you can keep going as you like. Also, when it does come time for audience questions, you each have individual mics at your seats. We're live streaming this event and recording it for our website, so it would be helpful for those listeners and viewers if you could use the mics. Okay, so I'm going to introduce the panel. I'm going to start on my far right with Alex Camarda. Alex is the Senior Policy Advisor at Reinvent Albany. Alex has vast experience in advocating for accountable government. He's worked, in addition to Reinvent Albany, he's worked for the State Senate, for the New York City Department of Finance, and for Citizens Union. So he's been on the front lines in a whole bunch of different places of these issues, including being an expert in campaign finance and election laws, which makes him particularly handy for today. Carey Dunne, to my left, is the General Counsel at the Manhattan District Attorney's Office. Carey was an ADA in that office at the outset of his career. He's also been a partner in private practice at Davis Polk. He was also the president of the City Bar Association, and you know, we could go on for an hour, so I'm just gonna leave it at that. So lots of different helpful experiences there as well. Jerry Goldfeder, to my immediate right, is a special counsel at the Stroock law firm. He's been an election law lawyer for 35 years, give or take. And has represented all kinds of candidates in all levels of government offices. He also was special counsel for public integrity to then New York State Attorney General Andrew Cuomo, and he teaches in these areas, election law, at the University of Pennsylvania and Fordham Law Schools. And finally, Nicole Gordon, over in the middle there in our tight quarters, is faculty director of CUNY Baruch College Executive MBA program and a distinguished lecturer in public affairs. She also was, most relevantly, the founding executive director of New York City's Campaign Finance Board, which, as you all know, has kind of become the model for campaign finance boards around the country. She also has worked in the foundation world and the nonprofit world and has served as counsel to the chairman of the New York State Commission on Public Integrity. She worked at the law department at one point, and she now teaches at Fordham and Cardozo Law Schools. So we have a real wealth of experience on this panel, and very excited to hear their thoughts. So somewhere there's a clicker to change the slide. Someone will get that done for me. So this all started for us at CAPI when we were asked by District Attorney Cy Vance to do an independent review and report and recommendations about campaign finance donation acceptance practices. As I'm sure you all know, back in the fall there were press reports about the decision not to prosecute Harvey Weinstein in an alleged groping incident and the decision not to charge, there we go.
There it is. Good.
Not to charge the two of the Trump children, Ivanka and Don Jr., with fraud relating to the Trump Soho project. And then some diligent investigative reporters learned that lawyers for those people had given campaign donations to Vance's campaign and said that there may have been a connection between the donation and the decision. So as all of that was going on, DA Vance decided to ask us to do this independent review, which we did. And we realized a few things right off the bat. One, we started thinking about what this problem was. And it can be a variety of things, right? It can be an actual corruption problem. You actually could have real corruption with giving a donation and then there being a quid pro quo decision, right? You also could have just an unconscious bias problem where you're getting donations from people, you know about those donations, they then come in on cases and you don't even really realize it, but you're kind of favoring them in some manner because you know they're donors to you. And then you could have, a very clearly, you're really not considering donations at all in making your decisions, but there's a perceived problem, right, of the type that the press identified in this case, where DA Vance said those donations had nothing to do with his decision making, wasn't even really aware that they had come in and so on, but still the press identified a problem and he got a lot of bad press about it for a while. So those are the potential issues you're talking about. And the problem is exacerbated because district attorneys have so much discretion and so much of what they do, of course, is behind closed doors for good reason. You don't want targets of investigation to be hearing that they're under investigation. That's not fair to them. And if they're never charged, they would never want their names to be out there. So this decision making is necessarily a confidential process. Not to mention grand jury secrecy rules and all of that. But that leads to a lack of transparency that leads some folks to be skeptical of the bases for the decisions. It's also exacerbated by the fact that donation limits, as they relate to district attorneys, are so high. In the city, donation limits are quite low, but strangely, DAs are kind of in this netherworld between the city and the state. They're county-wide officials, but for purposes of their campaign donation limits, they are governed by the state election laws. And the limits are quite high. There's a formula counting active voters, 5 cents a head, but in any event, for the big counties like Manhattan, Brooklyn, Queens, it's close to $50,000. So I think for the last general election for DA Vance, the limit was in the high 40,000s. So one person can give that much money. That's a lot of money. If it were a few $100s, you would say, even if people are giving that and then appearing in front of the DA, it's not enough money to look suspicious or make a difference, right? $40-some thousand is a lot of money. So that's another reason that this is a problem that we thought needed to be addressed. Donations need to be reported. State Board of Elections site contains lists of all donations over $100, I think, so people can go on and see who's giving to these candidates. So we also learned that, as I mentioned before, there's no real guidance in this area. You obviously have the donation limits, you have some election laws, but as far as kind of as an ethics matter, what DAs should be doing, how they should be considering this problem of actual potential perceived conflicts of interest, there's nothing out there, nothing from the bar associations, nothing from the District Attorneys Association. It's really left to individual DAs if they recognize that this is a potential problem, to do something about it and to do it voluntarily. So, we found some very general guidance on things like, prosecutors should act with good faith. Prosecutors should avoid conflicts of interest generally, but really nothing when it comes to campaign donations at all, which made it challenging. So what we did when we got this assignment was to, of course, do all of this research to try to see whether there were models out there, whether anyone had passed regulations that related to this, and they had not. We did look at what applies to judges in New York State, which I'll talk about in a minute when I turn to the recommendations, the blinding provisions where judges are not supposed to know who their donors are. So there are those provisions and regulations, but nothing that applied to elected prosecutors. So we just started talking to people. We spoke to lots of folks, including many DAs around the state. There's a list in the appendix, one of the appendices of our report, thanking and listing the folks that we talked to, just to get their ideas, try to learn something about their practices, and kind of bounce ideas off them about which of our recommendations they thought would work and that they might even be willing to implement. We also tried to crunch some numbers using some information that we got from the Manhattan DA's office and also the publicly available information from the State Board of Elections website. We really just wanted to know, when you look at someone's donations, how many of those people giving are lawyers, how many do we think are criminal defense lawyers. So we're trying really to identify the subset of people who might actually be in front of the office doing business with the office, because those were the people who we thought were problematic when it comes to potential conflicts of interest. So what we ultimately came up with is this list of recommendations. This report, by the way, is the report we did. It's available on our website. But this is a list of the recommendations that we ended up coming up with. And it turns out that DA Vance actually was doing many of these things already. And some of them he was doing partially, so that we recommended that he do, to a greater extent. But a lot of these things he was doing already, to his credit. So we recommended, the first thing we recommended was applying blind fundraising standards, and this goes back to what New York State judges do. The idea being that a district attorney candidate, whether a sitting district attorney or a challenger, should not know who is giving to him or her and how much. So they just kind of stay out of that whole process. And this is difficult to do. It requires a real kind of strict separation between the office and the campaign. The DA obviously could still be involved in kind of strategy stuff with the campaign and making policy statements and the like, but shouldn't kind of see the checks coming in, right? Shouldn't see lists of all of that. Now, obviously, all of this information is public on the Board of Elections website, so I've heard a lot of people say, like, that's so silly. I mean, they could just go online and look. That's true of the judges, too. It's also true, though, that, the information is still all coming into their campaign, so not only could they get online, but in theory, they could just access the information from their campaign. But you got to trust them to some extent, right? You have to assume some good faith here, and the process seems to work fairly well for the judges. It's a clean solution. It's a simple solution. If you don't know who your donors are and what you're getting, you can't be influenced by that, consciously or unconsciously. So we recommend that. The one caveat that we put on that was that we thought it was too strict to not allow district attorney candidates to attend their own fundraising events, even though it means that when you walk into a fundraiser, you see Joe and Mary and Tom, and therefore you know that they at least bought a ticket, which means that they've contributed. We just thought at the end of the day it was too much to say that they couldn't even do that. So it's not a complete 100% blinding, but we thought that was a good compromise. The second recommendation that we made was to refuse or limit contributions from parties with actual or potential conflicts. And this is the one that involves a lot of line drawing, which means it's fairly complicated because you have to kind of put different donors into different buckets and figure out who has the conflicts, and then we had to come up with some suggestions about what these limits would be. And many of these District Attorney Vance was already doing. Like, they already were checking to make sure that no parties to matters in the office were donating. So a criminal defendant, someone with a bench warrant, anyone who kind of would pop up in the system, they were already running those checks to make sure that those people were not donating. So we recommend that for all DAs. We also, though, recommended a limit on the lawyers who represented people in front of the office. And this is what was really new. All of this requires a decent amount of work on you call it the IT side, right, or the paperwork side. It means that you have to be taking your donor lists and checking them against your computer systems, your case management systems, to figure out the answer to this if anyone is giving. So, it requires some work. It's doable. I mean, if it's doable in an office the size of Manhattan's office, I think it's doable everywhere. I also was told that for smaller DA's offices, DASNY has case management system software that they provide. I mean, I think there are ways to get this done, but it does require work. So the way that we suggested it should work, as we kind of thought about what these limits ought to be, is we took a look at the city's doing business regulations and their campaign limits. I mean, you have to find a number somewhere, and we wanted to not just pick an arbitrary number out of the sky, so we looked at those limits. And what we ended up recommending is that for lawyers who are actually in front of the DA's office with a case, that they be limited to $320 as a donation. And that is the amount that a person who's doing business with the city can give in the borough president's race. We chose that elected official in the city because it's a county-wide office, like the district attorney. And we then thought about what to do about law partners who share in the profits of the person who's actually in front of the office. And because of that financial interest, we thought that they should be limited as well. So what we ended up recommending for that is we took the number that is the non-doing business number. It's the general contribution limit for the borough president's race in New York City, and it is $38.50, I think, $38.50. So that's what we came up with. People can argue about whether those are the right numbers or not. It seemed to us that $320 is not enough to be tempting for a DA to change his or her decision on something, but we also didn't want to completely ban lawyers from giving, not only because lawyers are typically a big donor base for district attorneys, but for good reason they want to give. We think that criminal defense lawyers and lawyers generally have a real interest in having a DA who's fair and capable and smart and all of those things and efficient. And so they should be kind of cut out of the process there, or at least not entirely so. So we also felt, though, that for smaller counties that those limits were too high because we have a chart in our report that kind of gives some comparisons, but as you go down in size for the counties, you really do see a decline in kind of the average contribution amount and the total amount collected. So these numbers are going to be too high, too influential in smaller counties. So for that, for those smaller counties, we recommended a 1% and 10% respectively numbers for that, which is about what the 320 and 3850 are for the large counties. We had to also pick a number for the time period that would apply. So if someone has a case, a lawyer has a case in front of the office, at some point that case will end. How long after that can they give again? Can they turn around the very next day and say, here's $5,000? So we said 6 months was a good period of time. So, your case ends, 6 months go by, you now can give without being in the bucket of having a case in front of the district attorney's office. So that's what we said, and suggested that older donations should be like a case-by-case basis. So if you see someone coming in with a donation and you look back and say, well, it's been 6 months since their case ended, but it was an enormous case, it got a ton of publicity, maybe we should say that, you know, we don't want to take this donation anyway. So the other recommendations we made are more of a collateral nature. Enforce a strict division between the campaign and the office. That's necessary for the blinding provision. It also just makes good sense and helps DAs comply with the rules about not using government time to campaign and that sort of thing. We recommended refusing campaign contributions from within the DA's office. As many of you know, city DAs are already prohibited by the Conflicts of Interest Board from doing this, but it is actually a practice in some upstate district attorneys' offices to collect from inside the office, which we just think is a bad practice. We recommended utilizing a comprehensive vetting procedure. DA Vance already had a vetting committee in place, which we thought was a good idea. We recommended, though, expanding the process, making it more formalized, especially if there's going to be blinding in place where the DA is not going to be kind of the final arbiter of whether to take a contribution or not. You certainly need to have someone playing that role who you trust, and you trust that person's judgment and so on. We recommended requiring a certification form for donors. That could be kind of your first check to try to see that this person and this donation is in compliance with all of your policies. The Vance campaign had such a certification form, so we took a look at that, and then we added some things to make it in line with the rest of our recommendations, but we recommend using that. And finally, we recommended publishing the campaign policies. We just thought that would help with transparency and accountability. It would help with the donors themselves understanding which donations are and are not okay with the campaign. And it'll help public perception, right? So the press and the public can see that the DA is serious about avoiding these conflicts and trying to keep all of that above board. So that is what we did. Now we'll turn to our opening thoughts by the panelists for their reactions. And I think the order we've decided on is Carey, and then Jerry, and then Nicole, and then Alex. And as I said, Isaac will let you know when you've spoken for 5 minutes, but don't feel compelled to stop right then and there. Feel free to stay in your seats if that's more comfortable.
I'm happy to stay in my seat.
All right.
Thanks, Jennifer. So thanks, everybody, for coming. I'm to make it clear, I'm not here to speak on behalf of the campaign, but it has been announced some time ago that the campaign has agreed to adopt all of the recommendations made in the CAPI report, and to go further, at least in some instances, probably most importantly, they've made it clear that there will be no contributions accepted from lawyers doing business with the office in the parameters that Jennifer described, but rather than allowing a $320 contribution to be made, that number for purposes of the Vance campaign is zero. What that means for our office is that we're now, as Jennifer alluded to, updating our databases and IT capabilities to account for that new requirement, which I won't get into the weeds unless you want me to, but it's actually a lot more complicated than you might think to do that. And I can describe that later to the extent people are interested. Because one of the, as you might imagine, and some of you know this very intimately, one of the awkward aspects of our current electoral system is, on the one hand, the people in my office really are completely walled off from the campaign and from fundraising. They don't make contributions, they don't solicit, they don't go to fundraisers, and they really never interact with campaign people or fundraising people of any, on-site or otherwise. I don't know what it's like in other offices, but people are really pretty paranoid about that in our office. On the other hand, somebody has to make sure that people who are contributing do not have cases or business before the office, and really almost by definition that has to be somebody who has access to our office's databases, et cetera. And so that is the one point of juxtaposition between the political side, if you will, and the DA legal side on the other hand. And for better or for worse, as Dan Alonso knows well, because he was one of my predecessors in this role, the person who sits on top of that one juxtaposition in our office is me. I'm happy to talk further about that and other issues as we go forward this morning. And I realize that's not 5 minutes, but I'll reserve the rest of my time for rebuttal. Thank you.
And this is not an adversarial proceeding.
We'll see.
Well, thank you, Jennifer, and thank my distinguished panelists for participating. Thank you for coming this morning. I've had the privilege of representing Cy Vance's campaign, as well as several other district attorneys, as well as many other candidates. So I've had the opportunity to think about and study campaign finance issues for many years, more years than I'd like to remember. And I have some issues with this report, but for the most part, I think it's an excellent contribution to the scholarship of campaign finance issues and campaign finance solutions. Let me just address a few points prefatory. Number one, there's very little one can do statutorily when a candidate or a donor is intent upon acting in a corrupt way. That said, legislatures have made attempts to reduce the role of money in politics by lowering contribution levels. And that has worked to some degree. Although the United States Supreme Court has ruled that those contribution limits can't be too low because that interferes with a candidate's ability to wage a campaign. For many, many years, I have advocated full financing of elections through public matching funds, the way we have here in New York City. Nicole will address that more thoroughly. We have a model here in New York which has really reduced the role of big money, but it hasn't taken money out of politics. People still contribute, and those contributions are matched. So we have the ability to reduce contribution limits, which does tamp down the temptation to be corrupt, because that's really what we're talking about. But it still exists. The key part of a system, whether it's public matching funds or just regular private donation system, is the aspect of raising money through bundling. So I can only give a certain amount of money for somebody running for governor. I can only give a pretty low amount of money for somebody running for city council here in New York City, because we have this program. But I can bundle money. I can raise money on behalf of a particular candidate, and therefore I'm looked upon very kindly by the candidate because I have not only contributed, but I've raised money from other people. That's really the key to having influence and access from presidential elections to New York City elections. I'm of the view that anonymous giving is probably the best solution. What Jennifer refers to as a blinding program that we have for judges. As a matter of fact, there's an ethics opinion that was issued by the city bar in the 1980s that said district attorney candidates as well as attorney general candidates ought not to be asking for contributions because they are quasi-judicial and therefore they ought to absent themselves from that fundraising process. Whenever I've I've counseled candidates, my clients running for district attorney or attorney general. For all the candidates I have represented, I think there was only one time where my client actually listened to me with regard to this particular ethics opinion, because after all, it was only an ethics opinion and not a statute, and therefore they went on their merry way and continued to ask for contributions. I did have a candidate this year who ran for district attorney in Suffolk County. And this was a very unique case. He was a police commissioner in Suffolk County, and there is an election law provision that says that if you are a police commissioner or a police officer, you can't collect money for a campaign. You cannot receive money in a campaign. So we had this candidate running for Suffolk County District Attorney who never asked for any contributions and never attended any fundraisers. None of this business of, oh, I'll attend a fundraiser and there'll be a few people there who won't give, so I really won't know who's giving. That's what judges do. That really doesn't work. That's an exception that swallows the rule. So what we did is we had this candidate not participate at all in the fundraising aspect. The statute says that he can have a committee, he can run for office, he can have a campaign committee who can then raise the money. And that's what he did. And he raised over $1 million. He raised $1.2 million. So I know that it can succeed. This was a model. This was unique. Most candidates don't like the idea of it simply because, first of all, they like to be able to interact with the people who are contributing to their campaign. And donors, of course, want to have some face time with the people to whom they are giving. But as an example, it worked, and it worked very successfully. He won. But the real significance is not that he won, that he was able to raise $1.2 million for this campaign. So how do you monitor that situation? Well, one can write up contribution cards where the donor will sign a statement equivalent of an affidavit that they say they're over a certain age, that they're an American citizen or holder of a green card, just like with any other contributor to a campaign. But also, I have not and will not divulge the fact that I am contributing to this candidate to the candidate. And the candidate, when disclosure reports are filed, can sign a statement that says, an equivalent to an affidavit, that I do not know the donors to my campaign. I will not review the disclosure reports. This is not foolproof, but given the fact that we have a situation where even low limits don't do the trick for potential corruption or appearance of corruption because of the bundling situation and because of people's natural affinity toward meeting with donors and donors wanting to meet with candidates. This seems to me to be the only workable solution. And those of you who might say, well, it's really not workable, I've tried to outline how it could be implemented. And I'm used to raising ideas that people think are not workable. 40 years ago, we talked about public campaign finance laws, and everyone said, oh, you can't do that, and we have a sterling system here in New York City. So an idea that seems like an outlier may very well be the only solution that can deal with this issue, at least as effectively as people are willing to sign statements that they will abide by it. In effect, we're relying on people's good faith, but we are also asking donors and candidates to sign what is an equivalent to an affidavit, and therefore there are civil and criminal penalties that support the system of anonymous giving. So with that, I suggest that Nicole Gordon will tell us about the way this great system here in New York works.
Well, actually, I'm going to reserve that for later.
Oh, okay.
Because I want to respond, first of all, to the report, and I want to make a disclaimer, which is that what I say is not intended in any way to be a criticism of any particular person, and especially including Cy Vance, whom I know and have great respect for, or for what I think has been a really good job done by the Center for Advancement of Public Integrity. But I start from the premise, which is not solvable within the constraints of what the report was addressing, and that is I have a very deep skepticism of self-policing. I don't think that you can expect there will be good guys who respect all their self-imposed restrictions, but that's fine, and we like them, and that's great. But that's not why we are looking for restrictions. We're looking for restrictions because we want to prevent bad guys from doing stuff they shouldn't be doing. So I start from that skeptical place, and I am eager to hear from people who know about self-policing programs that can be shown to have been very effective in the latter case of the not-so-great people. I think that my skepticism, I will just say, arises partly from 18 years of experience at the Campaign Finance Board, where we do have very strict enforcement and nonetheless still see abuses. And from two other experiences which have to do with the judiciary, but which I think are analogous to the DA situation. One was when I was chair of the Ethics Committee at the City Bar. We issued a report on the correlation between contributions to candidates for surrogates court and the appointment of guardians that surrogates court judges made, which can mean a lot of money for the people who are appointed. And those correlations, and I urge you to look at the report sometime, are just mind-blowing. So that's one. Those are two sources. And the third, I served on a commission that was intended, that Judith Kay put together to improve public trust in judicial elections. And we had a lot of very interesting internal conversations at the commission there. And these attempts to rely upon things like the idea that someone is not going to look at a public list of who his or her contributors are, I think is highly questionable. I think the temptation must be tremendous. I'm sure there are people who are able to withstand that. But I just think it's a lot to expect. And I think particularly if you allow people to appear at their own fundraising events where they do see the people who make the major contributions, I think it is a little bit beside the point. Just in that respect, I'd have one thought to the if it's feasible at all. I wonder if obviously would not make the fundraising events very exciting, perhaps, but maybe one could have a situation in which the candidate makes a videotape, and that's the way they appear at a fundraising event, so they don't see the people who are there. Although I don't think necessarily people are not going to know anyhow, but that's part of it. I also think that reducing the contribution limits is, although it's a salutary thing, when you're talking about judges and prosecutors, I include in this, I think a lot of people would like to appear in court on either side, not thinking that anybody had any relationship with the decisions that are being made outside the limits of the official exchange. And when I was on that commission, I mentioned a judge, a very prominent judge, said, I think that if you get $100 or have lunch with somebody, you should not be a judge in that case. I understand that because I think a lot of people, not all obviously, some have better restraints than others, but I think if you feel you owe somebody something because they did something for you, however trivial it may seem to somebody else, I think the question is always going to come to people's minds. I had some thoughts about things that could be done outside of legislation, which is the only thing I really would support as a meaningful change. But one question I had was whether on the vetting side it would make sense to have a third party, like an auditing firm or someone else, perform that vetting process so that there is some complete, well, nothing is complete, but an even more robust division of responsibility and somebody else taking some responsibility for the accuracy and veracity of those documents. I also wonder to what extent, and I know this is cumbersome, a DA should be recused, personally at least, not the staff, but the DA personally should be recused from matters that do come before the office that involve someone who's made a campaign contribution. I am, wondering also about the timing of contributions and how you deal with that problem, which I'm not sure I got fully. But if someone just hasn't yet made a contribution and then makes it later, and how that all fits in with who's in front of the who's involved in a particular case at a given time, I'm not clear on how that gets managed. I guess my conclusion, unfortunately, is not really so much a comment on what is being done voluntarily as it is a comment on the whole concept of trying to do these things voluntarily. And I do think that public financing of judges, and by close analogy, DAs, if we're going to have elections at all, is a better way to diminish the appearance and reality of influence that comes from the private sector on these offices. So that's my closing thought for the moment, and look forward to further discussion.
Good morning, and I also want to thank Jennifer and Cappy for the opportunity to appear on this panel today, and also thank my colleagues on the panel. And we also appreciated the opportunity to provide input into the report when Cappy made the recommendations to DA Vance's office. As was indicated, I work for Reinvent Albany. I'll tell you a bit about the organization. We're a 501c3 not-for-profit advocacy group. I myself am not a lawyer. I may be the only non-lawyer in the room, more of an advocate, so come to this from that perspective. Reinvent Albany was started in 2010 by a group of funders and our executive director, John Carey, many of whom were involved in transportation initiatives, particularly congestion pricing. And they grew frustrated at the time with the lack of progress when Mayor Michael Bloomberg first tried to advance congestion pricing in around that period. And they grew frustrated with both the politics and the process in Albany. And so that's really why they directed their attention to good government issues. As far as the report that was issued today, I think it's important to consider the voluntary reforms that the DA has made in the context of the system as it currently exists before diving into the specifics of the reforms which the other panelists touched upon. So I thought I'd talk a bit about the state's campaign finance system and then also the city's, which has been alluded to. So it's really a tale of two systems in New York. The New York State campaign finance system, which does apply to the district attorney's offices and for any candidate running for a state office, in our view is a very permissive and lax system and an example of what not to do. I'll highlight a few things that make the state system in need of dramatic reform. First, the state candidates, this New York State has the highest contribution limits for any state that actually bothers to have limits. A candidate running for governor can receive donations from individuals that are as much as $65,000. A family can give more than $250,000 to a candidate running for governor. Candidates running for the assembly, which represents roughly around 150,000 people in a district, they can receive contributions that are greater than that for candidates for the President of the United States. Corporations, while they officially have a $5,000 limit on contributions that they can make per calendar year to any political committee or candidate, effectively can give whatever they want because of the so-called LLC loophole, in which corporations can be created through limited liability companies. They're treated by individuals, as individuals for the purposes of campaign finance by the State Board of Elections, and therefore the individual limits apply to limited liability corporations. It's very easy to create an LLC. You can create multiple LLCs, so effectively there are no limits if giving through an LLC. There's also the party committees. Transfers can be made from party committees to candidates. Those do not count as contributions, so again, that effectively circumvents the already high contribution limits. There are no doing business restrictions. It's not uncommon in Albany to lobby a lawmaker by day and then go to their campaign fundraiser an hour later in the evening. Enforcement is fairly weak. It's been improved in recent years with the creation of a Chief Enforcement Council, which is an entity within the Board of Elections, kind of an entity within an entity. But just yesterday, the Board of Elections issued rules that they're putting out for public comment that effectively diminish the Chief Enforcement Council's ability to issue subpoenas on their own when they're conducting investigations. So that's the state system. There are a few redeeming qualities of the state system that I'll touch upon. One, there is robust disclosure of independent expenditures. There is pretty good disclosure of campaign contributions and expenditures through the filing reports of campaign committees. And there's strong laws and interpretation by the courts as to what actually constitutes a political committee. The city system, which we believe is a model and has been widely replicated by other municipalities, including in the past year, Washington, D.C., and also Philadelphia. We think is a model because essentially it enables candidates to run for office who might not otherwise be able to, because they can raise money from small donors through a 6-to-1 match of public monies for private dollars. And when they voluntarily opt into that system, it enables them, it requires them, to follow certain restrictions on campaign spending and fundraising. The contribution limits are somewhat high for the city, but far lower than the state. A candidate running for mayor can raise up to $4,950. That's for the entire election cycle. There are doing business restrictions where those who are lobbyists or have contracts with the city can only give up to $400 for a race for mayor. And I think importantly, the Campaign Finance Board, which is an independent entity that regulates the city's campaign finance system, has a culture and norms of being independent. It enforces the law, and that's really to the credit of folks like Nicole and others who, over the years, have established that culture. And so, obviously, the DA's reforms sit between these two systems. They are subject to the state campaign finance laws. And I think the reforms that were made are overall significant and meaningful, particularly the lower contribution limits that were stated, $320 for those who are lawyers who represent clients before DA Vance, and then also the larger amount of $3,850 for the partners of those firms. That is up to 99% less than it would otherwise be, which is $48,000 for a general election for a contribution to a Manhattan district attorney candidate. Obviously, it varies by county, but depending on which district attorney you're contributing to. But I think that's the most significant reform that was made among all the ones that were mentioned. And I do want to credit DA Vance's office in that, as an advocate, we visit elected officials often and talk to them about reforms. And usually the conversation evolves so that they're pointing you in a different direction to other entities, other elected officials. And it's actually very rare for elected officials to look in the mirror at themselves and think about how they can implement practices that make their own conduct, to have their own conduct have greater integrity. So we certainly appreciate that. And I'll get into the details of further thoughts on the voluntary reforms that were made as we proceed.
Great. Well, thank you all. We have a lot of things to follow up on now. I'm going to start with Carey. I know you don't want to get lost in the weeds, but maybe we could wade in a little bit to talk about how this actually works in practice. We're lucky enough to have all 4 of your fellow DA's offices here, and so to the extent that folks are thinking about, does this work, how does this work in terms of running the checks and so on, how onerous is it to do this? I know your system is unique to your office, but maybe you could talk a little bit about how that's done and how burdensome you find it, or is it easy enough to do?
Not easy enough to do. Sure.
Come on, Carey.
There's 2 aspects of it, I suppose. One, historically, our office has indeed run database checks against lists of contributions that have been submitted to us by the campaign. And historically, that is from 2010 to this year, those checks were to determine whether a contribution made by anybody on the list turns up to have been made by someone who either has an open case in the office, in which that person has been criminally charged, or has an open warrant for a past case, or, and this is where it gets more difficult database-wise, is someone who may be the subject of a non-public confidential investigation. And again, the weeds include, there are different databases that need to be checked for each of these purposes, and as you might expect, the one where you try to capture non-public investigations is sort of the most squishy, if you will, because the names of those being investigated may change in a particular investigation over time. It's not clear perhaps when exactly a name like that needs to get logged in the database of investigations, et cetera. So it's not an IT problem, it's a data entry problem really at bottom. That process now is being expanded for the reasons you just heard, to include the list of names of people who are contributors who are attorneys. And the way it's supposed to work, and this is still a work in progress data-wise, is that first and foremost, as you've heard from Jerry, I think, the donor is required to submit and fill out a form attendant to the contribution, in which the donor attests that, in addition to a variety of other things, if he or she is an attorney, they represent that they are an attorney that does not have a current case before the office or representing someone in an investigation, and has not done so within the past 6 months. And they further attest that if they do in the future 6 months from the date of the contribution get retained to represent someone in such a capacity, that they will contact the campaign and return the contribution. Again, as has been critiqued already, that obviously requires a lot of good faith and expectations, et cetera. I could comment on that, but I won't right now. And so that first and foremost is the way that hopefully the screening process will work on behalf, in a way that the donor is making these certifications and undertaking these obligations. But to backstop that, the data process and the IT process, as I say, is now being expanded to try to include lists of who the attorneys are that are appearing before the office. And that, when I say it's more complicated than you might expect, it's really because in the island of Manhattan there were 66,000 arrests and cases brought by our office last year. years ago, it was 100,000 cases. So that gives you a sense of the scale and scope of how many data entry cases we're talking about. To try to capture all of the attorneys that are appearing in all of those cases in different ways is quite a challenge, and our current data gathering process is not perfect and able to do that in all ways. Here I won't go into the details, but there's difference about who appears at arraignments and then who appears at a felony arraignment a week or 6 months or 2 years later, et cetera. If there, as often happens, of course, attorneys who come and go in a particular case, how and when do you capture that? We're trying to make sure now, for example, that there are people in every calendar part for every calendar call of a particular case to make sure that the information gathered in such an appearance includes the name of the attorney if a new attorney appears, and so that's reflected in a database. Historically, that was not so. It's a good thing to do for other reasons too, but that is new. And then, using that data thereafter through the IT process to capture that information on a 6-month forward and 6-month backward basis is, of course, even more complicated. So all of this is now being put in place, and again, it's a little bit awkward because some people say, well, all of this is resources being devoted in aid of the campaign. My response to that is no. These are resources being devoted to make sure that there are not conflicts presented in any particular case before the office. It's a prophylactic measure that the office has to undertake to avoid disqualifications and conflicts, et cetera. But that gives you maybe a little bit of a flavor of what's actually going on, the sausage making behind the scenes, to try to comply with this data requirement.
And what you just said raises another issue, which is this notion of a strict division between the office and the campaign. And, one of the, I guess, kind of catch-22 issues here is that the more that you have to run names from the campaign in the office and so on, you're kind of disintegrating that bridge to that division to some extent. So I'm sure, you have to be very careful about the people who are doing it, and
right.
And instead of the DA now sitting on both sides, you, I guess, really sit on both sides. So it's a challenge for you, a greater challenge maybe, to make sure that you're not, working
right.
on cases on the office side that involve, information you learn from the campaign side.
Right. Well, my own observation, just for what it's worth, is that all of these attempted fixes and critiques of those fixes are interesting and valid, but all of the problems and awkwardness that we're talking about, in my own view, stem fundamentally from the fact that we're talking about an electoral system, whether it's for DAs or for judges. And until the state comes to grips with that and decides one way or another whether that's needs to be changed fundamentally, we will have this awkwardness and these potential conflict problems that need to be addressed by imperfect fixes of the sort we're talking about. And that's just that. At the end of the day, it's not going to go away with the system. All those imperfect fixes will be necessary some fashion, given the nature of the system we have, like it or not. But in terms of the sitting on top of the information wall, so to speak, the way it's worked historically and the way it's working now, although since October the campaign has not been accepting any contributions and has not to date. So, but how it's worked over the years, as Dan knows, is that during the campaign and fundraising season or seasons, the campaign will periodically submit to, in this case, me, a list of donors who have contributed in the last month or some week-long cycle, or if there's been a particular fundraiser, and it's a spreadsheet that may have 12 names, it may have 80 names, depending on what's been going on at that particular time. With and it's the same public information that will find itself in the public website about the contributors themselves, the names, the affiliation, their job, identified job description, and their employer, and the amount of the contribution. And that's what then gets looked at by me, and I have one staffer who helps for the database searches. And we just go through and then determine whether there are any hits that need to be communicated back to the campaign. And it's not uncommon that something will come up, that this person has a warrant, or or we have to double check, is this the same person whose name appears in this database, et cetera, et cetera. Typically, in my experience, we have not until now had a blinding function, I think, within the office. But in my experience, I don't know what Dan Alonso's was in prior years, it's not a list that gets reviewed by the DA. And of course, given the public nature of these contributions, there has been no prohibition on that. But it has not, the list of names has not been shared beyond that vetting process, I will say. And now it has to be expanded and will be to include these lawyer names as well.
I'd just like to add to that, if I may, that even though what brings us here was a report that focused upon district attorney, this kind of vetting occurs in every campaign or most campaigns, whether you're running for president of the United States or the city council or governor of the state. There's usually a vetting process that the campaign goes through to try to ascertain who is donating and whether or not there would be a conflict or whether there might be an embarrassment. And so every campaign has this issue, and as long as we have a robust electoral system, and I think that we want to have a robust and fair electoral system, we need to vet. Campaigns need to vet. So again, it's not just about district attorneys, and it's something that's faced by elected officials or candidates for office on every level.
And Jennifer, if I can just add, just so the record is clear, because it may have been embedded in your last question, notwithstanding the process I just described, I do, and people like Dan before me have done, I sit in on every single meeting where there's a high-profile case of any sort that's under discussion in terms of charging decisions or judgments to be made about what should happen in this case or the direction of investigation. And I can assure you that never once has the concept of a campaign contribution or the name or nature of the defense attorney who may be involved in the case ever had any scintilla of influence or relevance to the decisions that are made in those meetings.
So I want to go now to you, Jerry. I really liked your idea of adding to the donation form this notion of I will not disclose to the candidate, and then the candidate could also affirm at the time of disclosures. That I think is a great idea. I do want to ask a little bit about the notion that with complete blinding and no attending a fundraiser and so on, a candidate can raise enough money to be effective. I know your experience in the Suffolk race was that in that case it was, but given your experience in working for so many candidates, I wonder if that's going to be true in other cases. When I spoke to folks familiar with that race, they pointed out that it was a somewhat unique race in that you had a sitting DA who was under investigation and then ultimately charged with corruption offenses. So you had an open seat with this kind of corruption issue. This candidate was kind of a reform type candidate. And I'm told that he had a real surrogate, a really strong fundraising surrogate who kind of played that role and really was a good person to raise money. And not everyone has the luxury of that situation. Usually the DA is going to be your most kind of effective fundraiser himself or herself. So, looking over your experience, do you really think that, this was not a unique, that this was a unique situation, it wasn't a unique situation? Do you think with complete blinding, it's really feasible that people can raise enough to do this?
I don't know.
Honest, at least. Good.
A candidate does a variety of things in order to try to be successful. They have a campaign manager, they have a group of people who get enough signatures to get on the ballot, and they have a fundraising operation. Supporters help the candidate in a variety of ways. And any candidate who is viable has a fundraising team. And let me rephrase that. In order to be viable, a candidate needs a variety of people working on his or her behalf, including those who can raise money. Optimally, a candidate should have a finance team, and most do. Most have a committee to help raise money. Sure, the candidate is the best viable, having a team of people who can go out and raise money for him or her.
Can I ask a question just to clarify? This is not meant as a criticism, but my understanding was that the candidate in Suffolk who successfully achieved election without publicly, being involved in the fundraising, et cetera, that was not his subjective choice to do it that way. It was because he was a sitting police commissioner.
That's correct.
I realize it doesn't diminish from the precedential value.
That's correct.
It worked, but in terms of the impact on other candidates and their decision to follow suit, that may be a factor, it seems to me.
I think that's right.
So, Nicole, we've talked about kind of the most obvious solution to this being public financing, right? If you're trying to get out
Or
of...
not having elections at all.
So that's what I was going to ask you about. So you mentioned that most DAs are elected, 46 maybe in the country, 46 states have elected DAs. It's not common to have appointed DAs, but a couple, I think 4 states do it. Do you advocate for that? Do you think that, because it kind of raises issues. I like the notion of appointed prosecutors. It seems to work federally very well. On the other hand, it's a nice thought that the people can elect their own local prosecutor and so on. So what do you think of that? Are you advocating for appointed DAs?
I'd like to come at it first from judges and then to DAs, because I think there's a possible progression there. I think you can have bad people elected and good people elected, and bad people appointed and good people appointed. In the case of judges, I think that having them elected is actually contrary to what their ultimate role is in the structure of government. I can make a case that having elections for your representative of your district makes sense. That's the democratic system, and you want a person to be having dialogue with the constituency and so on and so forth, and then advertising their positions on things and so on and so forth. But we all know that the rules that govern judges, for example, about what they're not allowed to say, what they are allowed to say, and what they should be doing vis-a-vis the public, are totally at odds with the whole idea of how you would run a campaign. How can you run a campaign without telling people what your position is? But as a potential judge, you're not supposed to be doing that. So so as a matter of process, and I'm not talking about results so much because I think they vary, depending on who's doing the appointing and who's doing the electing, all that, So I'm totally against elected judges. I think DAs come very close to those considerations because I think a DA has a special responsibility to the public to be representative of the state. Not to be promising, I'm not saying that this is what's a rule or requirement, but I think if you are hoping to have a person of greater integrity and quality, and we've been lucky in New York County, certainly, that we've had people who are terrific and they've gotten there through elections. So, I think there is a real tension between what the obvious donor base for a DA office is going to be lawyers, and precisely, more likely to be defense lawyers than not. So it creates a tension that I think is wrong for the system. So maybe I would conclude that it would be better to have them appointed, and I hope through a very complex process that would yield the best possible people.
Can I just say something about that with regard to District Attorney Vance's campaign? You'll know this better than I'll remember, but if I recall correctly, your report indicated that most of the contributors were not criminal defense attorneys. Is that correct?
Yeah.
I was talking to Jennifer. You wrote the report.
Yeah, I think we decided it was like 16% or 13%.
My recollection is that it's 13% were people who self-identified as working specifically for criminal defense firms, but 25% were self-identified as lawyers who worked for firms that had a criminal defense component. And it didn't mean that the donor was in fact a criminal practitioner, but you get the point. It's somewhere between 13 and 25%.
Right. Do we have,
So
well,
75%?
Yeah, but I'd just like to ask, do we have data about whether that is typical? I mean, Cy Vance, to his credit, is a well-known person and, you know, has a very high profile. I just wonder in the average DA race, whether that is, whether those proportions are similar.
So we don't, because we had information from Vance's office that we didn't get from other
others,
offices.
yeah.
We used the State Board of Elections information, the publicly available information to think about other offices, and they don't identify the professions of the donors. So we don't know. Anecdotally, from our conversations with other DAs, it does seem like there's a higher proportion of criminal defense lawyers who give in smaller counties. I think that's probably true, although, of course, it's hard to say. We did get some information from Nassau County, but it was only her first race, Madeline Singas. She got a lot of money from kind of the community and some of her former colleagues who were not in Nassau County. So she actually got, I think, a smaller percentage of people who were likely to be practicing in front of the office, but she wasn't yet the incumbent. So, you know, it's hard to say. But I think generally that point is correct, that Vance is going to have a lower percentage than some other DAs of criminal defense lawyers likely to be in front of the office.
If I can just add, I mean, I think that points to the need for a public matching system. I mean, I would have, you know, I'm obviously not a lawyer, and there are people in the room who work in DA's offices, but I would imagine that most people who come before the DA, whether they be defendants or victims or so forth, probably don't think a lot about the office until they have a matter before it. And I think it's really important that DA candidates be able to, and then incentivized to, go out into the community and talk to regular, everyday people about what their office does, because it's so important. And I think that would diminish the need to raise funds from people who have business before the office, even while I think these numbers are actually lower than I would have expected for at least the Manhattan District Attorney. Maybe they're higher elsewhere. But regardless, I think it points to the need to better explain the office to the community at large, and for a system to be put in place that incentivizes DAs to do that. I also wanted to touch on some of the...
Just with respect to that, you've almost persuaded me, by the way. I just wanted to know, do you know what the turnout is? Do you know what the turnout is for on the ballot? I mean, as you go down ballot for DA elections compared with other offices?
I don't know offhand. I mean, as I think most people in the room know, that the turnout for elections has dramatically declined for decades now, really going back to, I think, an erosion of confidence in government that probably began in the late 60s, and then following with Watergate. You know, the way registration has been done has changed, and that influences the turnout numbers as well. But generally speaking, in the city, election turnout or voter turnout has declined for 2 decades. I think it went up slightly with the last municipal election, but it's certainly, the overall trend is down, and that's for all offices.
And if I can add just a small but I think important point, it's true the democratic system we have, the electoral system we have, it has many imperfections. We all know that. But let's not kid ourselves. An appointive system for judges or district attorneys, there's a lot of politics that go into those appointments. And I would rather have an imperfect electoral system for district attorneys and judges than a system whereby a person or a independent, so-called independent group of persons are appointing a district attorney or judge, and no one really knows what the politics are that go behind that. We have a whole system of federal judges who are appointed by the President of the United States, confirmed by the Senate, but they're essentially appointed by the United States senators from their particular states, and God knows how that happens. We have some sense of what goes into their committees, the senators' committees that make recommendations, but it's really behind closed doors.
Whereas New York City voters, for example, really know the names of the judges who are on the ballot, and they know what they're doing.
She's being a little sarcastic, I think. It's an imperfect system, it's true, and down ballot races get little if any, attention. And a lot of those judicial races are not really contested. There are real imperfections. But on balance, I would choose having an electoral system rather than an appointed system, and try to fix whatever problems we can identify.
So Alex, talk to us a little bit, since you're probably the most familiar with actually getting things done, right? Passing laws and the whole process with that. What are the prospects in trying to get some sort of legislation that would mandate some sort of reforms in this area, some sort of limits, for example, anything. How are we going to do this? Is this going to happen?
Well, I think generally campaign finance reform is very difficult to achieve, as I think most people realize. I don't think there's been major changes to the state's campaign finance system really in decades. It's very challenging. I mean, working for a good government organization, most of the good government organizations have few resources. Even the structure of not-for-profit organizations, where you're limited, for example, in getting involved in elections in terms of the funding, limits you to doing public education and some lobbying. And I really believe that in order to achieve change where you're asking politicians to vote against their self-interest it's very needed, I think, for good government organizations to emerge that can do electoral work, to have more influence over elected officials. And so I think the prospects are very challenging to achieve any kind of campaign finance reform. That said, I think, for these particular reforms, if you wanted to codify what DA Vance has done voluntarily, I really think the District Attorneys Association is key in coming out in support for some of these reforms or other types of reforms. I don't think any reforms in Albany would happen without their endorsement, because they represent the people who are closest to the offices and have to live with whatever changes and have the real world experience. So I think any reforms would really need to emanate from that organization and then be supported by others. I will say, just coming back to some of the other items that were mentioned, we are skeptical of the blinding proposal for some of the reasons that have been mentioned. I think the self-policing aspect of it is the most problematic. I will say, with regards to the sheriff's race, I think if it's required in the conflicts of interest law, that obviously makes it something that's more compelling, because there's actually an outside entity that could enforce it and regulate it. I think when it's done by an individual candidate, it's much less meaningful. I think if a candidate is raising money and appearing at fundraisers, that really diminishes any form of blinding, even if they're not officially asking for the money, because obviously they're right before the people who would be donating to their campaign and might have even paid admission to come into the event. And another comment I had regarding the vetting process, in the report it suggested that the vetting be done more on the campaign side rather than having multiple individuals sitting between the governance side and the campaign side. I think that's a good recommendation in most instances. I would be a bit hesitant to apply that to the DA's offices, and I think that's because of the sensitivity of the database. I would be a bit uncomfortable with a political consulting firm or even campaign operatives having access to a database that includes people who have been investigated, and maybe nothing came of it. I feel a lot more comfortable with someone on the district attorney's side having access to that database exclusively, because they understand the sensitivities involved.
So we have.
I just want to ask
Okay.
a question. Yeah, I mean, we're familiar with decades of lack of reform in Albany on campaign finance, but most efforts have largely been for legislative races or executive. And I'm just wondering whether, I have this fantasy anyway, that doing something that was directed at judges and possibly DAs as well, trying to push for campaign finance reform that does not implicate the legislature, at least not in the first instance, whether there would be any greater likelihood of success, because nobody's asking them at that moment to regulate themselves.
I mean, I think it's easier, but still very difficult. I mean, look, in the budget, the last 2 years, the governor put in a proposal that would require, that would prohibit vendors from making contributions to the executive branch when they're submitting an RFP. Somewhat to my surprise, I thought the legislature might embrace that because it had no impact on their ability to raise money from the very same vendors at the very same time. And they did not include it in either of their one-house budget bills this year or the past year. And this was something that the governor advanced and seemingly would have happened if the legislature embraced it. So I would suggest that that indicates that there's little hope,
No hope, yeah.
given that that proposal didn't even pass, and that proposal was also put forth by the governor at a time where there's been trials related to upstate economic development projects and alleged bid rigging.
If I may address the point about my suggestion of anonymous donors, that procedure, both Nicole and Alex have referred to it as self-policing. It sounds a little pejorative when it's referenced in that particular way. My friend Jim, who's sitting in the audience here, has a designating petition where people go around, sign in order for candidates to get on the ballot. That's self-policed in the sense that there is a statement on the bottom of that petition, and all candidates, except for statewide candidates, have to petition in order to get on the ballot, whether you're a new candidate or you've been in office for 25 years. And it says, the person who goes around collecting signatures, the witness, says, I saw that person sign my petition. And this is an equivalent to an affidavit. So in effect, we have a ballot access system that is self-policing. And it seems to work. And every now and again, there are people who say that they witnessed the signatures to get someone on the ballot, but it's not true. It's a fraud. And no less of an entity than the Manhattan District Attorney has prosecuted folks for lying about getting signatures. So that's not really self-policing to the detriment, to the extent that there is no outside agency, in this case the district attorney, policing that system, and it seems to work. So I wouldn't just dismiss out of hand a system of anonymous donations because people are donors and candidates are signing attestations that they won't either reveal that they're making a donation or that they've viewed who is contributing to their campaign.
So let's take some questions. We have a little more than 15 minutes, and oh boy, we have a lot of questions. Yes?
So a couple of questions.
Could you use your mic if it's...
Sure.
Thank you. Push the button. Yeah, on the little console thing at the bottom, there should be it.
Got it. A couple of comments and questions. I guess my first comment is about the attempt to limit contributions. It is very attorney-centric, and there are other entities that have interests in how the criminal justice system is working, as I think the recent campaign for Brooklyn DA showed. So I think one of the challenges is to get beyond the idea that the only people who have an interest are attorneys, and that the primary donors will be attorneys. So if we are staying within our current system and looking at limiting contributions, I think we have to go to a much larger circle of people who are doing business as you were with the criminal justice system. But my question has to do with campaign finance. And it occurs to me that no one on the panel has talked about any of the other forms of public financing of elections which are available. And that DAs and judicial races might be a good place to use a system where every single registered voter receives a voucher. And the only contributions which can be made would be made to a blind fund where the voter themselves can match up to whatever number the public voucher, and the only thing which the voter would have to subscribe is that they are actually a registered voter and it is their own money, and they would only be able to make the one contribution in relation to the voucher. So I think that is a way in which to take care of the entire vetting problem and the entire problem of trying to figure out who should or shouldn't be donating, whether we should have different classes of campaign contribution limits depending upon the character of the voter, and really make this much more of a push to get the voter and the communities involved. Because what we're seeing, I think, increasingly on the part of the communities that are so significantly impacted by criminal justice issues is a burgeoning awareness that they actually do have a voice and that they could be demanding reform of the system that has so beautifully expanded the school to prison pipeline. And I think we need to be more creative in terms of the ways in which we're thinking about how to fund these races. So I'm curious about the panel's response to that idea.
Anyone have a thought?
Sure. Well, I don't know if Susan introduced herself, but she's the executive director at Common Cause, so knows these issues well. I mean, I think it's a great idea to look at different models for the judiciary. You know, in New York City, because we have the public matching system, you don't often hear the voucher system raised, which was recently instituted in Seattle. You know, it's relatively new. It's, I think, one election cycle in. And there's a group, Represent Us, which actually is a national good government organization that has backed that initiative, and they have been pushing that in ballot initiatives across the country. So it's certainly a valid model that's out there, different from what the city has. I think here in the city, you know, which those who are familiar are much more used to the 6-to-1 public matching system we have that's been in place for a couple decades. So, but I think that would be an interesting way to apply the voucher system to these other offices that are not currently subject to the city's system.
Dan?
So, interesting panel. Thank you very much for giving us the information. You've all talked a lot about how the candidate can protect him or herself, protect the perception of the impartiality of their office, et cetera. I haven't heard a lot about the donors, and who, after all, have First Amendment rights. I'm not talking about, you know, Citizens United and corporations. We're talking about people who sometimes might want to make a statement by making a, you know, if the district attorney did something or espouse a policy like, you know, not prosecuting marijuana or fair beating or whatever that I didn't like, and maybe the next time I want to send, you know, $1,000 to his or her opponent. That to me is very much a statement. I think people make statements when they give money to candidates, and you know, in particular, your system, Jerry, would completely obliterate that. So I wonder if you, Jerry, or others could talk about, you know, where the donor's First Amendment right, you know, being considered in all this.
Well, actually, my suggestion would not obliterate that. Donors give to candidates, contributors give to candidates for a variety of reasons, to give to campaigns for a variety of reasons.
But the candidate won't know about it, though. I want the candidate to know. It's just my statement. I want the candidate to know about it.
You want to know, you want to connect the candidate
Yeah,
with
I'm
you
talking about
personally?
me, but I mean, people, you can imagine donors wanting the candidate or the world to know, this is my statement, $5,000 in favor of the governor. You know, that's what I'm saying through my donation, and why would yours not take that away from me?
You're able to give to support a particular policy or to oppose a particular policy. That's not eliminated. You're just trying to eliminate the candidate knowing about it. But you're fueling a campaign either for someone or against someone by giving money, and so therefore you're able to exercise your so-called free speech by contributing. The fact that
And it's public. I mean, everyone else can see it too, right?
No, then maybe I'm not understanding your suggestion. I thought nobody could see it because
Oh, no, of
I'm
course
signing a
it's
statement
disclosed.
saying, oh, it's disclosed and it's publicly on the Board of Elections website?
Of course, if I didn't make that clear,
So I
I
misunderstood that.
apologize.
I'm just not supposed to tell the candidate that I made the contribution.
That's right.
Okay.
Both Nicole and Jerry have pointed out that judicial races and prosecutorial races are a little different, and I agree with that. Maybe it's time we go back and re-examine Buckley, and that is the whole principle under Buckley was that you represent, that there's a free speech aspect to representing the people who elected you. But judges and prosecutors have a higher duty and a higher function than just representing the constituents who elected them. They have an independent function that maybe distinguishes them, and we could go back, instead of trying to deal with it from the demand side, we look at it from the supply side, or whichever way you want to do it, and say, you know, there really should be spending limitations and rules for judges and for prosecutors. And the one other thing, I'll say briefly, I don't want to monopolize a lot of time here, and that is, Jerry pointed out correctly that a lot of what a candidate depends upon is not just the $500 or $200 that they receive from a donor, but it's who puts together their campaign, who carries the petitions, who does the press, who does the reach out to the clubs, who does all of that campaign work, and who gathers, who's the treasurer. Being a treasurer of a campaign committee is an awful job. Who does all that work? Those are the people you really become indebted to. Those are the people you say, oh my God, thank you. And I don't see anything in the recommendations. You deal with contributions, but you don't deal with participation, which is where the real ties that bind occur.
Yeah,
I think that's a good point.
I mean, I guess we didn't think about that because those are not people likely to be in front of the office, right? So it wouldn't be tied to the decision-making of the district attorney.
I couldn't disagree. Having run a judicial campaign, I couldn't disagree more.
Right.
Well, right, I mean,
I mean,
So just to muck this up, what Jim is referring to, of course, is a perfect example is when he ran for judge and he appeared before various political clubs. And those who supported him, he may have felt indebted to. And what their positions were on particular issues, he may have felt that he needed to reflect that. I'm sure he was an objective, and I mean this quite seriously and honestly, I'm sure he made decisions based upon what he thought was right all the time, because I know him. But not every candidate is like that. And so he's right that it's not just the contributors who a candidate might be responsive to. It's the entire, it's various groups in a community that are supporting or opposing in that race.
yeah, I mean, look, so I guess what I would say is that the vetting function, right? So you have your person in there who's now kind of taking the place of the DA to say yes or no to certain contributions and trying to figure out the conflicts, would say, oh my gosh, look who just showed up in a case. It's Jim Smith, and he was the campaign treasurer. You know, we can't take this, you know, we can't deal with this. And I don't know, you'd have to have some recusal procedure or something, I suppose. Yeah, that's, I mean, we did not think about those people at all who give, I guess, kind of in-kind contributions.
I don't want to monopolize this, but I do just want to follow up on that. And that is, Alex made a really good point earlier. At first, I was troubled by the fact that public money is being spent on a campaign expense. And that is, as Jerry pointed out before, vetting is usually a campaign expense. If a judge were to say to his clerk or her clerk, spend half of your time looking at my campaign contributions, you'd all get outraged. If an assemblyman or a senator had someone on staff who spent their time looking at campaign contributions to make sure they're clear, you'd be outraged because public money shouldn't be spent on a campaign vetting expense. Now, and I was about to complain about that until Alex made a good point, and I haven't solved this riddle. I don't know how you get around the fact that you really can't turn the vetting over to your contributors or your campaign. I don't have an answer to it, but it's very troubling.
Well, but so Carey addressed this before when he said, and I think he's right, that even though he, as a part of the district attorney's office, is looking at campaign contributions and so on, he's not protecting the campaign, he's protecting the office, the integrity of the office. So, and you can say that about all the other offices as well. So there's no perfect way of doing it, but it seems to me that where we want to go is protecting the integrity of the office. And if that requires somebody from the district attorney's office to spend part of their time vetting, then that's something that we need to do.
I would just add,
It's an issue with the governor's office right now.
well, I mean, again, I would just add this, again, part of the imperfect process that needs to be in place, because I don't see a way to make it more perfect than it is right now. And on the terms of the vetting, someone mentioned before the prospect of, maybe the vetting should be turned over to some outside third party, like an audit firm, et cetera, et cetera. I think as someone's already responded to me, that's more imperfect than the other imperfect solutions, in particular because at some level, when it gets dicey or close to the line or difficult, the judgments that need to be made have to do with the judgments in a particular case, given, say, who the defense attorney is, or when he or she last contributed, or what the relationship is with people in the office, or the status of the case at a particular time. These are not judgments, A, that can be made by outside parties because they should not be privy to some of the information here, and B, they're not attuned and expert enough in the subjective decisions that need to be made in order to make those decisions if they're trying, an audit firm trying to apply some objective standards. So I think that notion is not going to work for those reasons. I thought, Jim, where you were going was a more general critique of the notion that, putting aside who's actually made contributions, if the people who are appearing in the office had made no contributions, but were the prior treasurer of the campaign, or one can just fill in the blank. Right. They were law partners previously before the election, and now, to me, again, it's an imperfect world, but there's no way that you're going to, in my judgment, be able fully to, get around those kinds of questions, except to the extent you have a vetting process that says, you know what, I am going to recuse myself here, or I'm not going to take this meeting there, given the status and what's going on right now in this particular case. But, it's one thing to say, yes, we can count how much money people have given, and that's a proxy for trying to get access. If you put that aside and say, the DA or his subordinates have friends in the community who happen to be defense lawyers, who happen to be respected and are hired by high-profile individuals, I don't see the way that you're going to turn those defense attorneys away at the gate and say, sorry, you're too friendly with people in this office. So if you have a remedy for that, let me know.
Hey, Carey, don't get mad at me, but what about his question, what about his statement that if he did it as counsel to the speaker, or working for an assembly person, or working for the governor, and if he was involved in vetting, he'd get indicted? What about that?
All I just fall back to is it's a different function, and there are cases that need to be brought, and there are people involved that you can screen out through, contributions, those sort of things. I think it's closer to the question of, are you doing business, are you a vendor that's seeking a contract with the city of X, Y, Z, as opposed to, you're too close to these people. Maybe that doesn't answer the question, but I think it's a different function.
Let's take this gentleman in the front. He's been very patient.
Jerry, one of your partners wrote an article in the Law Journal before the election extolling Vance's integrity. But he referred to the situation of campaign receiving contributions from Harvey Weinstein's attorney and the attorney for the Trumps as a mess. He characterized it as a mess, and he analogized his view of Vance's integrity to that comparable to Morgenthau and Hogan, who were his predecessors, long-term occupants of the DA's office in Manhattan. And I wrote a letter to the editor of the Law Journal pointing out that neither Hogan nor Morgenthau ever got into this mess. What can we learn about the way they conducted their campaigns, and what can that teach Vance or anybody else who's running for DA?
Well, so first of all, I was, and I am a size campaign lawyer. And
your firm, in that article, Joel said that your firm represented the campaign as well.
That's exactly right.
Right.
That's exactly right. So I remember the article that he wrote. I agreed with some of it. I didn't agree with all of it. But I think the reason why it became an issue now as opposed to in the past is because we have a more vigilant media looking at contributions and decisions and so on. And given the context of the so-called Harvey Weinstein issue, it became a public at a time when the tabloids went to town on Cy Vance, who I am not embarrassed to say is probably one of the finest public servants I've ever known or worked for. And the idea, and forgive me, Jennifer, for going off like this, but given the question, the idea that Cy Vance could ever be compromised by a contribution to me is ludicrous.
But what about the appearance, though? I mean,
and that's why we're here.
Yeah, the appearance of
that's why
the cynics out there, among which the tabloids fuel the cynicism. They see cause and effect when they see that Vance's campaign accepted a contribution from Weinstein's lawyer, and Weinstein wasn't indicted. And
I understand.
You'd make the point that Vance's integrity would prevent any connection being, but the guy on the street doesn't share your view of these things. And the appearance of impropriety has a significant value, particularly when we're talking about the district attorney's office. He has vast, prosecutorial discretion. When he chose to prosecute the Abacus Bank, for instance, he got a lot of criticism for that too. The vast discretion, that unreviewable discretion of the DA demands that he never put himself in a position where it may appear that he's compromising his integrity. I think you have to agree with that.
So we understand your point. That is why the district attorney, that's why Cy asked this Center for the Advancement of Public Integrity to evaluate what occurred and to come up with recommendations, and that's why he has a system in place going forward that will address that. And that is why we're here today, to discuss these kinds of issues.
So
there's another point.
We need to wrap up.
Quickie.
I saw one more question in the back, I think.
Can you answer why you haven't mentioned the recommendation that Cuomo made that this matter be investigated by the Attorney General?
That's outside of the scope of this matter. We didn't evaluate that decision. It had nothing to do with that. This was about recommendations to change practices going forward to try to avoid these situations. Sir, in the back?
I was just going to bring up what happened in the Philadelphia DA race, where George Soros funded a PAC in the last month or so before the election that completely changed the dynamic of that race, and whether Cappy looked at any. I mean, I know they're impossible to regulate, but whether that was a consideration at all.
We didn't look at that. We were asked to do something very narrow, and so we didn't even really think too hard other than mentioning it about public financing and legislation and other things, because we really were just trying to answer the question we were asked about voluntary measures. It's an interesting point, and it's one that was raised by another district attorney when I was talking to some of the DAs about voluntarily taking on these practices. Someone said that exact thing. He said, well, what about when George Soros comes in and pumps a bunch of PAC money into my race? How can you hamstring me from raising money the way that I need to combat that? There are some inequities inherent in our recommendations between incumbent DAs and challengers. I mean, you know, there are just no conflicts if you're a challenger because you're not sitting in the chair, you're not making decisions. So you wouldn't be limiting your donations in the way that we propose. So there's just kind of some inherent inequities there. I don't really know how to make it equitable between incumbent candidates and challenging candidates without then losing the kind of backstopping recommendations that we've made. You know, it's just kind of inherently a problem, but that's an issue, and I mean, again, something that legislatively needs to be addressed in terms of where money is coming in through these PACs and trying to get more transparency into that process. But yeah, I mean, you've hit on one of the kind of fundamental concerns, I guess, about inequity in different kinds of candidates. And we thought a lot about it and, you know, didn't really come up with a perfect solution, but you raise a good point.
I was just going to add, I mean,
from Alex?
you know, with what you're describing as independent expenditures, and it's really a constitutional issue, and we referenced earlier the Citizens United case, and short of disclosure, there's not a lot that can be done other than a change to the Constitution or change to the Supreme Court where they change their previous ruling. And it's something that, you know, all of us think about when we think of lowering contribution limits. There's a concern that that money will then flow out to independent expenditures. And I would also say in regards to the last comment about the perception issue, I think Cy Vance acknowledged that there was a perception issue, and it's part of the reason he took the action he did. Obviously, there's a bigger perception issue in Albany with all the different state legislative races, the races for governor that has not been addressed for years and ought to be. And I think, you know, elected officials should respond when there's a perception issue or actual conflicts and address them. And, you know, we give credit to the DA for doing so in this instance. And as I mentioned, we think the reforms are meaningful, they're significant. Could more be done? Certainly. I think a lot of legislative change needs to happen.
All right, well, thank you all for being here. Please join me in thanking our panel for this spirited discussion.